Welcome. My name is Michael Coyne. I'm the Associate Dean of the Massachusetts School of Law at Andover, and this is the Educational Forum, a show produced by the Massachusetts School of Law at Andover and shown nationwide. Today's topic is great teaching. How does an institution ensure that it has great teaching? How do we know that those teachers inspire their students in class and try to elevate their performance to another level? What qualities does a student look for in teachers that are great teachers, great instructors? What should our teachers be doing in order to ensure that they get the maximum performance from those students? Today we'll examine this topic from the perspective of the institution, from the perspective of its faculty, and the perspective of the students that sit in the classroom. Please join us as we discuss this important topic. Our first guest today is Lawrence Valvell, the Dean of the Massachusetts School of Law at Andover, and this institution has placed a great deal of emphasis on teaching well. Are there special reasons why an institution, relatively new, nearly 20 years old like MSL is at this point, adopts methods to ensure that its teaching is really superb?
Well, yes, I think there are several of those, Mike. To begin with, when we started, we felt that without getting into all the things that happened, because that goes way beyond this kind of program, I mean, books have literally been written about it, we felt that we had to establish a reputation for some particular ability or skill, something we would be known for. And we chose two things. We chose teaching, and what was extremely rare at the time, we were almost unique, is focus on practical lawyering as opposed to merely the theoretics of the law. So that was one reason. A second reason is our faculty are those kinds of people, and in this life you tend to go with your strengths. You tend to go with the things you're interested in and that you're good at. And our faculty were particularly interested in that. And then, too, you come down to the fact that I mentioned before, that I think the Socratic, or in our case, the discussion method of teaching, is the greatest engine for teaching people to think ever invented. There is a school of thought which says, and I know of no reason why it's wrong, that law schools as a class, unlike, for example, schools of economics or schools of psychology, or schools of history too, for that matter, have not made any real intellectual contributions to American society. They're highly reputed, they're very difficult, the people who teach in them and who go to them are supposed to be very smart, but that's all different from making a serious intellectual contribution to the society. But if there is one place where I think law schools have made such a contribution, I think perhaps the only place, it is that in the Socratic method, or more appropriately in the discussion method, they have invented the greatest engine for learning to think that has ever existed. Now, we want our people, because by the nature of the geography here, our people who have come from state institutions, they have not generally come from Harvard and Yale, and such like. We want our people, and our people need, when they are done here, to be able to compete with people from those institutions, because that is the nature of the lawyer population in Massachusetts and in New Hampshire, where our people are going, and elsewhere in New England. And in order to ensure that our people can, as they do in fact, compete with other people on what has come to be called a level playing field, an even basis, call it what you will. You're just as good as the next guy. That's what it comes down to. We want them to come out of here having learned not only practicalities of lawyering, which other schools don't teach, but the thought process and how to think about the law and about everything else in life too, because you can't learn to think about the law without also simultaneously learning, inevitably, how to think about other things in life. Thinking is thinking is thinking. Whether you're a lawyer or an accountant or an economist or a businessman or a person engaged in everyday life. And the techniques of thinking are the same. And so when people come out of here, we believe that they have been prepared not only to think well and therefore be able to compete with other people in the law, but to think well, period, and to be able to apply that in all aspects of their lives.
You know, many people say that law school changes the way you look at things. You can never look at things the same way again. I take it, based on what you've said, is that you believe that's all for the better.
I think law school and learning to think in general, as done in American society, tends to cause people to be very adept, very adroit at taking things apart, taking ideas apart, taking reasons apart, criticizing individual facets of same. What I think we're not so good at, and I'm not speaking about here, but I'm speaking about in general, is teaching people how to put things back together again in some constructive way. A simple way to think about this, as I have done from time to time, is when we are done, if we were a school of engineering or a school of car care, our students would know very well how to take apart an engine. Like guys can do it with M1 rifles, you know, blindfolded. Yeah, people would be able to do it blindfolded. But do they realize that as a whole, this is an engine? And do they understand that the great invention is to have created an engine in the first place? Now, this is not a new idea on my part. This goes back to at least to Theodore Roosevelt, who said the honor and the glory should go not to the guy who's standing off on the sidelines carping at what other people are doing, but the man in the pit who is sweating and bleeding and trying to create something. So I think that, and I hope we do here, it's also necessary, it's necessary not only to teach people to criticize, take apart, and all the reasons for it, blah, 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 but also to understand that there comes a time to construct, to build. But of course, the method of thinking we're teaching also helps people to build better, because when you're considering how to build, well, will this work? Well, what are the reasons for? What are the reasons against? What are the facts? One way and another. So that the method of learning, the method of thinking is essential and useful there too.
Doesn't the case study method, the problem-solving method, help to teach people to construct and not just destroy whatever it is, the arguments that are advanced?
You know, Michael, I really don't know. I take it from the very fact that you asked the question that you believe it doesn't, so I should turn the question back on you to answer, quite frankly. Yeah, no, really, but I'm serious about that. See, in my experience, I haven't taught for a while, as you know. In my experience in Ann Arbor, no way. And in my experience teaching at Kansas and at Catholic, no way. I have a notion that here a lot of you are doing it differently, so that one could not say no way.
I think that's true. See, I do look at the problem-solving method, the case study method, as a process where the student actually tries to achieve solutions, to try and correct the injustice and to try and fix the problem. Because I agree with you. I think far too often many law schools teach people how to destroy the logic in someone else's argument and not spend enough time on building the strength of their own argument. And I do think the case study method, I think the problem-solving method, which is variations of what we've been talking about for the last half hour or so, all have a tendency to develop greater problem-solving and consensus-building skills, hopefully, for our students to be able to represent their clients better in the long run. The style of teaching that MSL hopes to cultivate among its teachers, is that natural, or how does one work at acquiring those skills?
Well, I think that for a professor, for anybody who goes into the academic world, because people going to the academic world tend to have a desire to, well, they're born pedagogues. I don't want to say pontificate, that's not the right word. But they want to present information. The natural instinct is to lecture to people, to share your information with them. It's hard for people to learn that one ought never to make it, in my view, ought never to make a declaratory statement, that it's always questions, question, question, question. If you say this, how about that? Well, then how about the third? And so on. So this is not a natural style for a pedagogue. So it has to be worked at, it has to be learned. One has to be criticized, frankly, in the way that we criticize people through tapes, through visiting their classes, through asking them to visit other classes, see how it's done, and so on and so forth.
I want to ask you a few questions about the class we're about to see.
Sure.
When I looked at it, I thought it was a great class, first of all.
Thank you.
But what I noticed most particularly about it is that you had to put a fair amount of planning into it, and you also had to really think about a topic, or topics as it turned out, that would really sort of excite the students and grab their attention. Do you think those are some of the keys to really good teaching?
I think it's critical. I mean, I think no matter how long you've been teaching, and I've been teaching here 16 years, it is really important to prepare for your class so that you will have a really good class. That's what our goal is in any event. We had just finished offer, acceptance, and consideration, some of the critical aspects of contracts. And we were starting to take a look at what are some of the defenses to enforcement. And we begin with illegal contracts. Well, the textbook talks about the black and white cases. They talk about if you enter into a contract to have your husband murdered, is it enforceable? Well, of course it is not. And we look at things like bribing a government official. Everyone knows that's illegal. So what I'm trying to do is take a look at some of the cases that might touch on public policy and whether those contracts should be enforced. And we do that by taking a look at more contemporary issues that are not in our textbook, and so you have to plan and prepare for them. What I have found, as you have taught me, that our students like a laugh now and then, and they really like to see the professors in peril. So what you're about to see is you and I in situations of peril.
And while using humorous examples, you're able to fully explore all aspects of the legal issue and engage the students in a fairly interesting discussion.
That's right. I base those particular hypotheticals, if you will, on real situations, but I design them so that there are issues that are raised by the court in those particular real cases that I can vary the fact pattern with the hypothetical to touch on issues that the court discusses.
A couple of other things I noticed about the class that seem to make it go very, very quickly were that a number of different students were touched on in fairly rapid succession to debate each other, in essence, or to add to the discussion, and that the pace was fairly rapid as they, in fact, stood up to discuss some of the topics. Why do they stand?
When you're a lawyer, when you are in court, you are standing. So you have to train them right, I think, from the first day, that if they are speaking, they are standing. And they speak in my class one at a time because that's what we should do in court to show that we're respectful. So I think that's really important that they're standing. So also they can be heard by all the other students. So I think it's important. I'm also a runner, although many of you would say a slow runner. I like to think of myself as a fast runner. So accordingly, I try to really run an upbeat tempo class. I mean, I try to move the discussion. We have, although we have very small classes overall, some of our first year classes are quite large, and I want to have everybody active and involved in every class if I can, or certainly the thread of it, so that they're prepared and ready to go.
Okay, great. Let's take a look at the class.
So I want you to assume that I am 8.5 months pregnant. About 9 months ago, I was inseminated for $100,000 to deliver a man's baby because his wife is incapable of producing children. And they wanted a biologically related child. The agreement that we entered into was quite extensive, but let me read you some of the significant terms. The terms are as follows. I would be entitled to no monies if the child was stillborn before the 4th month. Additionally, I promise in the contract that I will sever all parental rights and I will surrender custody at birth. The contract also gives me no right to rescind the agreement once I sign my name. And all parties have signed on the surrogacy agreement. Furthermore, I want you to assume, for purposes of this hypothetical, that there is a state statute that says baby selling is illegal, and it is defined as follows. Baby selling is the exchange of money in connection with an adoption. All right, folks, I cannot give up this baby. I've grown attached. Represent me. Do these type of cases belong in court? Where else are you going to decide them, right? Do you feel that you could work it out in the best interest of everybody here? Ephraim, you got to show off that beautiful shirt.
I'd say I make a case for the father of having rights to the baby because the mother was willing to give it up for $100,000.
Okay.
She obviously didn't want it from the get-go. He obviously did. He's willing to pay her.
Well, perhaps her motives were very good. My motives might have been wonderful. I might have said, you know what? I really want to help this couple. What if it's my sister? What if it's my sister who's incapable of giving birth? And what if I do it for free, Ephraim?
Oh, that's a different case.
Okay, that's a different case. So if I do it for free, I get to keep custody?
He's going to have a hard time getting custody of that baby.
But I signed my name to a contract.
Of course, not going to enforce a contract. That was against the statute.
Is it against the statute? Jesse disagrees with you. Why, Jesse?
Because what that clause does is make the contract about the baby itself. It's not about your time, it's not about your efforts, it's about successful delivery of the child to the father.
Okay, and why is that significant?
Because it refutes Mike's argument of a few minutes ago that the contract is not about the baby. The contract is about the baby because you could spend your time, have a stillborn child, and be out your money.
Devon?
And furthermore, where it's saying that it is about the money for the delivery of the baby, that's part of the statute. And then if the wife had planned on adopting your child, then that would be the adoption piece of it that might be able to make the argument against.
That it violates the statute. Okay. What is the public policy behind allowing these type of agreements? What argument could you make on behalf of the father that these agreements are within the best interest of society? Jillian?
Well, there's no other alternative for this couple to have a child. They should
Right.
be entitled to it.
There may be no other way for this couple to have a biologically related child. And isn't that an important public policy that would foster these types of agreements? Down in the library, you will see that I have left for you to read the story of Baby M. The surrogacy agreement, what's happened to Baby M since we had the long battle, the 7-month battle in court, and what her life is like today. What I'd like you to do before the end of the semester is read what's on reserve. What if the ski resort were negligent? I mean, they could have padded that pole. Most ski resorts do. They put padding around, they paint them yellow or bright orange. Yes?
Well, the form that he had torn off was a standardized form. And the print is so small, and there was no bargain in exchange for the terms. So it's either take it or leave it.
I had to take off my glasses to see it. What if you got on ski goggles? Right? You're not even going to read it, are you?
Right.
And you really want to go skiing. You paid for a week's vacation. Does that matter?
I would think that they would be liable for the injuries because it wasn't a bargain for exchange. You didn't agree. There was no meeting of the minds for this standardized form.
What if instead of hitting a pole, he gets hit by somebody on one of those snowboards now that they come flying down the mountain on? What if he gets hit by somebody on a snowboard?
Well, was that person negligent on that snowboard when they came down?
Does it matter?
I would think if they were negligent in the way that they were coming down, you would have a suit against the person that was operating that snowboard along with
the ski resort. What if they let skiers and snowboards on the same slope? Isn't that negligence? Jesse?
On the other hand, if what you're opening yourself up to is an adhesion contract that frees these people from even taking reasonable precautions to keep you safe, common sense precautions, if there was no fence behind home plate, for example, so that, yeah, you release them from all liability, but in exchange for using your ticket, and there's no refund, and they didn't even bother to try and keep you safe, you could argue that that's unconscionable, to not take reasonable precautions.
Stephen?
Well, because this is an adhesion contract, I'd like to know what information he got when he, prior to going there, paid for his week's vacation, whether he was aware of that or not.
No, I mean, all he got was the two things I showed you, the peel off and then the ticket.
When he got there, and I think that's a material fact, as I believe is the unnatural pole that is not necessarily there as another tree might be, that wasn't lit during twilight, that should have been. Probably has a case on the contract law and tort law.
I'll tell him you said so. The question really comes to this. Can you release yourself from your own negligence?
Are there some things that everyone can do that would make them more effective teachers and therefore their students better performers in class, do you think?
Yeah, there are some principles that we try to stress in the memos that we pass around and in the mentoring programs that we have. The first principle is pay attention to pace. Obviously, dead air lasts a lot longer than one would think. And if you're allowed to have dead air in the class is going to shut down if there's consistently dead air. So try to keep the pace up. 2 is try to involve as many students as you possibly can in the discussions. Sometimes this means having a discussion with several students at once. If you go into one of our rooms, it's not unusual to see 3 or 4 or 5 students standing all at the same time and engaged in a discussion both with each other and with the professor.
When you say discussion, do we mean like debate, exchange of ideas? I mean, fairly a rigorous exchange of information?
Yeah, of course, the form can take many shapes, but I think with the word rigorous, you hit the nail on the head. It's up to the professor to challenge the students, and in this regard, tension is good. There should be some tension there. Now, I'm not suggesting that the student should be necessarily nervous or afraid of the way that the professor is going to react, but the student must know that the professor is going to push the student to get to the heart of the matter and to use his or her brain. Soft answers should never be accepted. So we teach the students to challenge each other as well, always politely, we hope, but they're required to challenge each other as well. So often we pit students against each other. That's one format we can take. Some professors have students act as advocates in court. You take the plaintiff's side, you take the defendant's side. Sometimes that works well. What I found is experimentation works. Use different methods to try to evoke this type of rigorous discussion.
Would you use a variety of methods during the course of a semester in a given class?
Oh, I think these days you have to. We have a diverse student body. The student body obviously has diverse learning styles. Some students learn best visually. Other students learn best by listening. Other students learn best by reading. Other students learn best by getting into small groups together and debating the issues themselves. So I think you really need to be most effective, you need to use several different methods of teaching.
And so during the course of a given semester, you might employ all those methods to try and ensure that the student's performance maximum performance is achieved?
Oh, absolutely. I think you have to. Certainly more than 1 or 2. You know, we went to law school in the day where we learned by reciting cases. What are the facts? What's the holding? What did the court say? What's the rationale of the decision? And we'd be grilled by the teacher while the rest of the sometimes 100-student full room would just watch one professor and one student going at it. Well, the case method still has its place in law school today. There's no doubt about that. But it certainly should not be the only method of teaching today.
When we talk about the discussion method, are we talking about problem solving, case study, case analysis? It's a whole method of approaching material as opposed to the lecture format that is employed elsewhere?
Yeah. Discussion takes more than one person speaking, obviously, and the definition of discussion is discourse, to have more than one person speaking. So, the lecture method is a very passive way of teaching. The professor speaks, the students sit and listen, and maybe the most active the students get is taking notes, physically taking notes or typing into their laptop computer. There's no give and take. There's no challenging of the students. There's no making the students think during the class. They're there only receiving information. In the discussion method of teaching, you're forcing the students to interact. You're forcing them to push back when you put out ideas. And we found over a number of years, almost 2 decades now, that that's the best way that students can learn, is when you make them active learners as opposed to passive learners.
Great. Let me ask you about a class of yours that we had an opportunity to take a look at. It was a landlord-tenant class, small group discussion, it appears. Tell me the things that you were trying to accomplish in that classroom.
Well, the first thing you'll see is that I used hypotheticals in that classroom. This is a very common method that I use to teach classes. I write hypotheticals in advance. sometimes I pass those hypotheticals out to students in advance so they can look at them in advance.
When we say hypothetical, what that really means is sort of a fake problem?
It's a fake problem that could very well happen, or maybe has happened, quite frankly. I often use real cases to write my hypotheticals, cases that the students haven't seen before. And this is a wonderful opportunity to have an interplay between the case method of teaching and the hypothetical method of teaching. So, for example, you can have a student recite a case and tell you about a case that they had read as part of the assignment, and then try to draw subtle distinctions out by using hypotheticals to follow up on the points that the case raises. So you really can take that case and turn it upside down and sideways and look at it from a whole bunch of different angles.
And that then stretches the student's understanding and perspective on the issue?
Sure. What if? The student comes in just reading the case, thinking, well, this is the law, this is the rule. Well, real law is not like that. With real law, you never get the exact same case twice. So you have to make the student consider, what if this, what if this, what if this? Hypotheticals are a great way to do that.
Let's take a look at that class and see if you were able to accomplish that.
I hope so.
I do too.
Craig, very polite, as we all know, apologizes for the inconvenience, but says, well, now I'm a tenant, and you're going to have to go through the full eviction process, and it might take 60 to 90 days, thinking, of course, he's going to get 60 to 90 days of free hotel living, and says, no, I'm not going to leave. So, Faith, you're going to have to evict Craig at this point, or treat him as something other than a landlord or a tenant. What's your argument here, Faith?
Well, I'm saying that Craig is not a tenant because he really doesn't have any interest in the land or the property. The type of accommodation he's staying in doesn't lend itself to a full-time living. It probably doesn't have cooking facilities, and he hasn't signed what we consider an actual lease or rent of this property over a long term.
Now, you're not saying that you have to sign a lease to create a landlord-tenant relationship, are you?
I'm not saying that, but you have to indicate by some means, whether it's oral or signatory, that this is going to be a tenant relationship. I'm saying that even though Craig has hung up posters and pictures on the wall, this is not a living situation. It's not somewhere he can live and cook. It might have a bed for sleeping, doesn't have place for cooking. It isn't an abode. And he has really no interest in the real estate or the land as such, which he would have to have as a tenant.
Okay. So a person staying in a motel or a hotel is not living there?
Well, they're not considered a tenant. They have a license to stay there versus a tenancy. And a license would then require that we don't have to go through the long eviction process.
Okay, we'll come back to that, the distinction in a minute, license versus tenancy, but I want to hear Craig's argument.
I think this is now my home. I'm a tenant at will. The paperwork that we signed didn't have any particular end date, and as is tradition in the motel business, you invite people to stay there as long as they want to. The hypo says that you came up and knocked on the door, which I answered, which infers that I have exclusive possession and use of the premises. Clearly, I've established that I want to stay there long term. I've hung up my posters, my easy chair. I believe I'm a tenant at will here, and you're going to have to go through the 60 to 90 days.
Okay, anyone here? Desiree.
Well, Craig mentioned exclusive possession.
Mm-hmm.
Well, in fact, in a motel or a hotel situation, you don't really have exclusive possession. Maid service can come in. If you're ordering room service, they come in. You can get your towels left for you when you're outside of the hotel. So, in actuality, the manager, Faith, was just being considerate to you by offering a knock, when in fact she has the key and can get in any.
Professor Desiree.
Well, my personal case is I live in a home with my mother, of which neither of us pay rent, neither of us own. The owner of the property is my grandfather. For 25 years, my mother and I have lived in that property and have never once paid rent. It was built specifically for her. There's no mortgage on the property. all that my mother and I pay are utilities and the costs of daily living. So my question, I guess, in my hypo would be, are we engaged, my mother and I, or just my mother and my grandfather, are they engaged in a landlord-tenant relationship? Or is this a licensee situation where we just have use and occupancy of the premise and my grandfather can kick us out to the curb at any time?
Well, what do you guys think? Is this a landlord-tenant relationship, or is this
It sounds to me like it's a landlord-tenant relationship, even though there is no consideration paid for the privilege of living there.
Well, let me ask you
The
this.
consideration is driving him around and taking care of him.
Well, but that's a good question. Does consideration show more a license relationship, or maybe I should say lack of consideration? Does it show more of is consideration a question that bears more on license contract law, or one that bears more on real estate law?
I would say contract.
Contract law? Okay. So if there's lack of consideration, then what do you think?
I'd say I have a landlord-tenant relationship, or at least my mother does with.
You don't need consideration for a landlord-tenant relationship because it's a property interest, right?
And I think that over 26 years, they've established the conduct of a landlord-tenant relationship by how it works.
What about the fact that your grandfather, lets you know before he comes in? Or even if he did come in, what if your grandfather, does he have by the way, does he have a key to the place?
Oh, absolutely. Yeah.
And if there's an emergency or something like that, can he come in?
Of course.
Does that bear on if the person who would be in the position of being a landlord has the right to come into the premises? Do you think that's dispositive? Is that going to make it potentially a landlord-tenant relationship or not a landlord-tenant relationship? What do you guys think?
I don't think it matters. Because, a landlord probably has the right in most cases to come in for like an emergency if he owns the property, to save the property, or maybe a pet or somebody else in the property that can't fend for themselves.
So is the question really is the question really whether you have exclusive possession, or is it whether you have the right to exclusive possession? And am I just making a semantical argument? Am I splitting hairs here, or is that important? Faith, you nodded your head.
I think you have to have the right to exclusive possession. I mean, we have run across situations where a tenant has had the right to exclusive possession. The landlord has let himself in on numerous occasions without permission of the tenant, and that creates a violation of that tenant-landlord relationship. But the tenant surely does have a right to exclusive possession, whether or not they pursue that right.
Peter, that seemed like an interesting class. Landlord-tenant appears to me to be sort of an easy one to be able to use hypotheticals that would appeal to the students.
Gee, thanks, Mike. I was going to try to take the credit for that, but that's okay.
Are there other courses where the principles are equally applicable, even though the subject may be a little more foreign to the students?
Sure. Just about every class you can get real life situations into the class. And you're right, landlord-tenant law is very easy. Because just about every student has been a landlord or a tenant at some time during their lives. So they really do relate to that class. But a more difficult class might be something like constitutional law, for example, where you're sometimes discussing abstract notions of natural law and difficult concepts that the Supreme Court has come down with. You still have to find a way to make the student relate to those situations. It's more of a challenge, but I submit that if you give it some thought beforehand and you prepare, you can always find a hypothetical that the student can relate to, or you can always find a line of discussion that the student can relate to.
Will the jury please rise? Will the defendant also please rise? Madam Foley, has your jury agreed upon a verdict?
Yes.
What say you, Madam Foley, as to complaint number 154, where the defendant is charged with operating a motor vehicle under the influence of alcohol? Guilty or not guilty?
We found the defendant guilty.
Okay, thank you.
This is
On behalf of the litigants here, I want to thank you for your attention that you've given this matter. And this is perhaps the most important part of this whole exercise, because they're sick of listening to me all semester.
Do you find that the hands-on training, the actual simulated courtroom setting, helps to stimulate the students' appreciation for the material and depth of understanding of the material?
What I find is that it's closely interrelated with certain subjects. Obviously, they have to draw on their substantive law courses, whether it's a contract case, a tort case. But more importantly, I find that students really come to learn and appreciate evidence more. Because as you're aware, teaching evidence yourself, evidence is merely a compilation of rules. And it's the rules on how we play the game. And if you haven't played the game, it's very difficult to understand these rules. So if you've never seen a football game and I were to give you the NFL manual on the rules, you would not understand what a clip is, an illegal receiver downfield, if you've never seen a football game. If you've seen it, then you read the rule, it's easier to understand. Once students have taken evidence and then they take a trial skills course, it dawns on them, oh, that's what that rule and evidence meant, because they're applying it through the testimony of witnesses. So I think it makes evidence come alive for them, and some of the concepts they may not have understood, authentication and so forth, they really start to understand it better.
And that's, I guess, my last question or point for you is that you really did use that whole process at the end to provide feedback to the students, either by way of the jury or by reminding them lessons about direct examinations, topics you had discussed during the course of the semester. Is that really what we would call a good teaching moment or a good learning moment, where they really can, right after the exercise, get that feedback that has some real value to them?
Absolutely. The benefit of these type of courses is they get immediate feedback. Obviously, during the semester, we do isolated examination of witnesses. We do different problems. This is a chance for them to put it all together and see how all the pieces work at the same time. And that's their final exam. And they get immediate feedback from the jury. And when the jury is recused and they're dismissed, rather, then we give them further feedback from some of the legal issues that I would discuss with them. But they do get immediate feedback, and I think that's very important.
Well, thanks, Anthony. Let's look at the rest of that class.
What I'd like to do is address the very first part of the trial. You heard the opening statement, and that's an overview of what the attorney thinks their case is about. And you first heard from the Commonwealth. And let's start with Phil. And I know this is Phil's section right over here. But after you heard the opening statement, did you have a good overview of what the Commonwealth case was about? Did he explain it clearly to you?
He's my husband.
He's your husband.
That's hard.
No, but did you understand? Because did you understand what the case was about? Because they know the case so well. When they get up and they do their opening, it makes sense to them, but it may not make sense to you. Did it make sense?
I think it was
All right.
pretty clear.
How is his delivery?
And it was good too, because with everyone used like normal language, not technical talk that someone in the jury may not understand. You know what I'm saying? So everyone kind of talked like a normal, I want to say like 8th grade level.
Was he too hard on defendant?
It made him seem that he was too confident in what he was saying.
And did you like that or not?
No, I didn't like that.
Really? Okay. Now I want to explore that further. As far as styles go, do you want the attorney to be confident, or do you want
like overly confident, where he's like practiced too much,
too smooth, too
smooth.
practiced?
Yes.
Yeah, I think it's because he was representing the Commonwealth, and his point was, these are the rules, these are the regulations, this is the law, and that to me was
okay.
important.
On cross-examination, both under Carla and Phil, they asked questions that were open-ended, and we have commandments that you have to follow when you're asking cross-examinations. And the both of them are sinners. They're leaders here. Phil and Carla did the cross, and that's different than direct. And on cross-examination, you're supposed to put words in the witness's mouth. You're not supposed to ask them, well, why do you feel this way, or why did you do this? And that can be very dangerous if you get an experienced witness on the stand, because they can go on and start explaining. And did any of you notice in the cross-examinations when they asked a question like that and the witness gave them an explanation?
Yeah, you did start to get more than maybe they wanted you to have.
Yeah, okay. That's a comment that, and it happens to everyone. It's human nature. You just do that, but that's a commandment. All right, so now let's talk the closing arguments. Did anyone make up their mind before the closing argument? And I'll have you out of here in a few minutes. Before the closing arguments, did you have your minds made up? All right. Other than you, after closing argument, did anyone come up with did you come up with how you were going to vote after the closing arguments? Show of hands.
Professor Capani's class was a great example of a simulated exercise or role-playing where students actually try a case from beginning to end and then, as you saw, receive the feedback from the jury and Professor Capani with respect to their performance and especially as to how they might improve their performance the next time before a jury or before a judge who would be evaluating them. In the next segment, we're going to discuss with Professor Connie Rudnick a much more traditional law school class. In this class, students had read cases, they had understood, hopefully, the material, and now they were going to be exposed to the debate in the classroom about each other's ideas, about a hypothetical, and about the law, as it turns out. Hi, Connie. Thanks for joining us.
Thank you, Mike, for having me.
How important in your teaching do you find these problem-solving type exercises in order to help develop the student's understanding of the material?
I think it's essential. I adhere as much as possible to hypothetical discussions, whether they're really hypotheticals or they're actual cases, because that's what lawyers do. Lawyers solve problems. And there are steps in the problem-solving process, whether a lawyer does it consciously or unconsciously, that I want the students to be able to do. They get a set of facts, which are the client's problem when they walk into the office, and they're going to have to understand how not only to best present their own client's problem, but also to best defeat and anticipate the argument that's going to come from the other side, whatever that is. And so that's why I use hypotheticals and try and get as much discussion back and forth.
Do you find that at the end of the day, when we're done the semester, that by the use of role-playing and problem-solving and the really a lively, engaging debate in the classroom, that the students have a better understanding of the material?
Oh, I think so, and I think it's not just an understanding of the material, the law itself, but an understanding of, and this is very cliche for law schools, but how to think like a lawyer, because it's critical. You have to understand how lawyers approach their roles as problem solvers, and by using real problems in class, as opposed to just a strict case method, you force them to go beyond just what did that particular judge say in a particular set of facts, but to use those facts as lawyers use precedent to apply to the real life situation of the client who presents themselves in their office.
Great, thanks. Let's take a look at your segment.
Okay.
Well, let's look at the Fordham case for a second, because that's really sort of an extreme example. How many people think that Mr. Fordham got a raw deal? Okay, John, why? Why do you think that Mr. Fordham, if you remember, Mr. Fordham charged $50,000 for an OUI. If you were Mr. Fordham's lawyer, what would you have argued to the Board of Bar Overseers that to support your contention that this is not a disciplinable action?
Well, here the clerks, they specifically looked for the best trial lawyer, right? And they wanted him because they knew he was going to win, and they only wanted certain parameters in their representation, meaning they weren't ready to deal and they wanted a straight acquittal. If they wanted just a DUI lawyer, they already went to several of them, and they weren't happy with any of them. They specifically looked for this guy out because he had a special talent. He may not have been a DUI lawyer, but he was a litigator who always wins and was the top notch in his class. And
okay.
That comes with a price tag. I mean,
so paying for the experience. What else? What other factors might you have argued?
Well, this might be the same that John argued, but it was an informed decision. This is the exact. I mean, they knew there was nothing that was left out. They knew that he did not exactly what John said. He had the experience as a great trial attorney who has results in what he does, but specifically that he has never tried an OUI case. They had the opportunity to interview, I think, at least two or three other people who specialized in only OUIs. They did it for years, and they knew what the rates were, so they were aware of what comparable rates were. He disclosed his billing practices. He told them everything. So these people were completely informed, and they made a knowledgeable decision to accept that.
Okay. What else?
And the clocks were billed monthly, and they never contested.
Yeah. What about that? What about that fact? Good point. They knew what was coming down the pike. They knew it's not like they got a bill for $50,000 at the end of the whole case. They got periodic bills. They knew. I think that there were bills up to $20,000. So they knew in advance that this was not going to be a $10,000 drunk driving case. Bart?
They also had the opportunity to discharge him as an attorney. They didn't need to continue representation.
Where's the obligation to the client here? What onus do we put on the client? If the client's not happy with the way this is going, it's $20,000 and you haven't gone to trial yet, why don't they just discharge the lawyer?
My question for you guys, and we'll start with Jesse since you're on the end, so you've got to grab a microphone. What qualities do you think make a great teacher? I mean, whether it's grammar school or high school or college or even law school now, what are the qualities the professor or teacher has that make you want to come to class to learn?
A certain amount of personal charisma is important, so the ability to make it interesting. And I think structuring the course so that it's focused on the student getting a hold of the information as opposed to a recitation of what the teacher already knows or a way for the teacher to show how smart they are, whatever it is. And you can tell when a course is structured to make a body of information accessible to someone who's never seen it before.
Well, how does a professor then, or teacher, structure it such that you feel that you're maximizing what you can get out of that class?
I think a focus on clear definitions of new terms, not assuming that you know a lot. I think breaking things into pieces that are sort of manageable, big enough that they still make sense if there's a structure that has to be built, but not, here's the whole course right out front, have fun digesting that for 16 weeks. Discrete pieces that you can manage is also really important.
As a general matter, have you found that enhances your learning ability or the manner in which you receive the teacher is if you become more active learners?
Definitely. I think you need a high amount of interaction between the students and the teacher and between the students among themselves, discourse back and forth. I think that interaction is key to a good learning experience.
What other qualities would you guys like to see when you go into a classroom and have a teacher for a given course?
I think the best quality a teacher can have is showing that he or she cares for the student and just not at work trying to make a paycheck, trying to get a paycheck rather. If you actually show that I'll spend time with you after class and maybe after I spend time with you, I can spend more time with you on a given day instead of just showing up for class and after class converse with your peers, because I think if you're coming into a new situation, you and your peers on the same setting, and they're not sure as well as you, so that person can't lead me out of darkness, but if the teacher will actually spend more time with me and quite possibly explain it to me, I'll have a better understanding.
Let me ask you about that, because that's an interesting point. At some point in college and grad school, I think professors and administrators, we tend to think, well, you guys are adults now, you just want to come for class and run out. But Darius raises an important point. I mean, the interaction outside of class, the time spent with the faculty and teachers beyond the classroom experience. Is that important to you still?
It's very important. And I agree. Some teachers hold you to that standard, like you're in law school, look it up. And I totally agree with that. But it's different when a teacher avails themselves to you and say, okay, what steps have you taken to research this problem? And if a student just exhausted all their means and they really just want to okay, like, can you please just show me the research steps I should have taken, then that's just taking that extra step forward to be like, okay, fine, I care about the student, I care about my students, and I want them to get the material. Not that, like, when I was in law school, I had to do it this way, so you should do it the same way. Times are changing. And I can respect a teacher who's hard in the classroom, but also engages the students to the point where, like, you know what, your opinion matters. The courts aren't always right.
What teachers have you had that have inspired you to do great things, and how were they able to do that? Go ahead.
I found that the best quality a teacher had here was actually just learning the students' names. Being able to sit in a classroom and not just pointing, but saying, you know, Jesse or, you know, whoever is up there, knowing their names, to me, makes the difference between caring about the class and not. The teacher takes the time to learn who you are, then I feel like even more so I have to, you know, make sure when I show up there, they know who I am. I don't want to be embarrassed anymore, so I prepare even harder for that teacher.
You know, you raise an interesting point, Spence, because what happened when people have come in to inspect the school in the past, other people at other law schools and like, they have said, well, you guys know the students' names. And that seemed to be sort of a baseline one would expect, is you should know the people who are in your classroom and who you're teaching. Hopefully that you have some level of interaction with them and know more than beyond their names so that you have a better chance to reach them. But it's not a given everywhere that you actually do know who it is in your classroom and can relate to them. What other qualities are you looking for to really be enthused about coming in and learning the material? Michael, you've been quiet so far. Do you have something over in the corner for us?
I think that a good teacher should be a good mentor, someone that can lead by example and teach others how to work and to learn in the environment. I also think that people have different gifts, and they're given those gifts. And I think the beauty of teaching is that the teacher is able to, or the instructor is able to open the person to something that they can realize in themselves and be able to experience some kind of new learning process or new experience that can help them to develop as a person.
What teacher influenced you the most and why? Whether it's, I remember my second grade teacher, I remember my sixth grade teacher. I actually remember some teachers I didn't like at the time, and now as I get older I learn, gee, a lot of what they had to say, they were much more right on than I was willing to accept at the time. Any of you have experiences like that of some teacher that really made a difference that you still carry with you?
I think we all had that type of experience this semester where we started out a course and we were like, oh my God, she wants so much from us, this is so hard. And then after you start getting through it and you start getting in the rhythm, you realize how much you have learned and how well that, you know, teaching and learning process has worked. And you can't necessarily appreciate it when you're in the middle of it because it's a lot of work and you're kind of plodding through and you're not sure you get it. But when it all comes together, I mean, that makes the difference. And it has the stress, but it has the interaction. And I just think it's a really good, you know, culture for learning.
What other teacher did you have that influenced you in a significant way?
Well, my mom's a teacher, so she's influenced me all my life. But when I got to undergrad in Morris Brown in Atlanta, I had two math teachers who told me that you can basically learn anything if you apply yourself. So that's kind of the same motto that you have here. If you, whatever time you put in here, it'll show on your test in the classroom, and once you actually get your JD, pass the bar, and become a lawyer. So if you put the time in, the finished result will be you.
One thing that I found was my fifth grade teacher. She was very funny, affectionate. She knew each one of us, took the time to chat with us, whether she came and had lunch with us or whatever else. But a big thing was if the students didn't understand something, she wouldn't just repeat the exact same thing she said before. She'd approach it from a different angle and another way to try to get the method or the idea across to the kids. I know my middle daughter's having trouble with her math teacher because he explains how to do something, and the kids raise their hand, we don't understand that. He explains it in the exact same terms. She said, no, I heard you. I don't understand it. So that's a big thing, is being able to come at a problem from different angles. Kids.
Yeah.
I had a high school teacher, English teacher, and she pretty much always used to drill home in my head, think outside the box, like you're limiting yourself. I wasn't the best reader throughout high school, even parts of college, but she would always tell me, if you sit down and you put the time, like Darius said, into your work, and just don't limit yourself to that particular sentence or whatever. Think outside the box. Apply yourself. Like, see if you can engage the reading to the point where it's like you're inside the book. And every time I read something, I try to, like, okay, what does this mean? I ask myself, I'm thinking out of the box. Like, I'm not limiting myself to that one sentence. I'm reading between the lines. So, that's all thanks to my 10th grade teacher, and she was just amazing.
Thanks for joining us. We hope we gave you something to think about today. We think great teaching is an important topic. I hope you found the discussions informative and enlightening. What we do know is that the topic of great teaching is an important one, and that it takes an entire institution, its teachers, its students, and its staff to ensure that everyone performs at a very, very high level, and we maximize student performance and learning. We hope other institutions follow the same lead. Again, thanks for joining us. We'll see you next time.